And welcome back. Will Worsham joins us now for this week's Speaking Legal discussion. Always good to see you.
Will.
Good
to see you, too.
for coming
Good to see
in.
you.
You ready?
Yeah, sure.
We stumped you last time, didn't we?
No, never.
Okay.
We never stumped
I was
you,
thinking
no.
of somebody else. Okay.
Yeah.
Here it is. I loaned a friend of mine some money a few years ago when they lost their job. Now they're working full-time, seem to be doing well. They've purchased a new vehicle and paid for landscaping around their house, but have made no mention of paying me back. I don't have anything in writing, but is there anything I can do to get my money back? This is probably not all that unusual.
No, it's really not. So the question is, first of all, I would say, well, have you asked for it? You know, I mean,
Right.
I mean, you would hope that you wouldn't have to do that in that situation.
Yeah.
But I mean, I think the first step is ask for it. It's like, hey,
Yeah.
you know,
Seems like you're doing okay.
Talk it over.
a
It's what
plan.
you say all the time.
yeah, you know, you don't want to involve the legal system if you don't have to. But realistically, if that's not going to be an option, you can go to court and ask to be repaid for this amount of money.
Mm-hmm.
I would have thought that would have been just his word against my word.
It absolutely is his word against your word. And that's why a judge gets to hear what everybody has to say and decide who's telling the truth and make a decision based on that. Now, as the plaintiff in this situation, you have the burden of proof, but it's only the preponderance of the evidence, which means the court only has to find it more likely than not that you're telling the truth in order to render a verdict in your favor. So it's not like beyond a reasonable doubt, like in a criminal case. It's a much lower burden you have to prove. And your sworn testimony is evidence that a court can consider in a situation like this.
Do they actually go and say, okay, when was this driveway purchased or when was this? Do they go into that and find out those things?
Well, as far as those things, I don't think it's going to matter. The fact is, did this person borrow the money? Was it clear that there was intent that you were to be repaid? And can we find that that was to happen and yet hasn't happened yet?
So what are the objectives? How do they, I mean, I don't understand if it's just word against word. How do they decide? Two people have a different story. How do you prove it?
That's why judges get paid well.
Oh.
They have
Yes.
to make that kind of decision.
Yes.
Now, realistically, in a situation like this, we're assuming that the debtor is going to lie. I think that's actually pretty uncommon in these scenarios. I think it's more likely that they're going to come and probably maybe make some accommodation and say, oh, well, gosh, you know, I'm sorry, I guess we really need to do this. I don't want to have to go to court. You can take depositions. You can do all kinds of legal process, interrogatories, which, depending on the amount of money involved, may be worth it or may not.
Could you say, here's my bank record for that date, and it shows I made a withdrawal. Let's find his bank record and see if he made a deposit?
Yeah, you could attempt to subpoena those records and use that to support that. If the money was loaned on a check, it would actually be possible to show that you wrote the check. I actually saw a case one time where when the person wrote the check, put in the memo line loan. You know, there are some other scenarios here like, well, was there a time set for repayment or not? If there wasn't, then the judge is going to have to kind of judicially create that in the scenario and try to determine that it's reasonable. So when we just say, here's some money, that's really not, if you really, really, really intend on being paid back, that's not the best way to do it. You want to establish some parameters and you want to write something down. But in this particular question, there are things that can be done. We're not in the best situation that we could be if we were seeking to get paid back. But it's not a situation where you just have to throw your hands up, bite your lip, and take it.
Is this small claims kind of thing, or is this, again, something you really need to talk to an attorney about?
It's really going to depend on the amount of money involved. If it's a relatively small amount, it very well could be a small claims court. If it's a larger amount of money, it could go into a regular associate or even circuit court proceeding. Now, we're going to run into potentially a different problem there with what's called the statute of frauds if we get into talking about too much of money, and that's a whole different class in law school.
What is the small claims? What is the amount?
That's
up to?
$5,000.
Up to $5,000.
Okay, so up to $5,000. After that, now you're probably a good idea to, even if you're getting around, I mean, $5,000 is a lot to me. I should probably talk to an attorney, at least that consultation to get advice.
Absolutely. And what I'll tell a lot of times people about small claims court is you don't need to hire a lawyer to go to small claims court. I personally hate going to small claims court because the rules don't apply there, and I went to school to learn the rules, and so I want to be in a place where I get to use that. So I'll usually tell people, go ahead and bring your case in small claims court. If you lose, then you have an automatic right to a new trial in the Associate Circuit Court where all those rules apply. Talk to me then.
Now I can help you out.
But let me just say real quick, just them getting something from small claims court could prompt them to pay you.
Yeah, just filing the petition
Right.
could make the debtor here go, oh, I
Yeah,
really want to
I
pay
think
you.
I'll pay you.
I better do this.
Yeah.
Okay.
Of course, the best policy is don't lend friends money, just give it to them.
Absolutely.
There you are. Absolutely.
Right.
Just give it to them.
People want more information from you, Will. How do they get it?
We're at willworshamlaw.com or at 863-9455.
All right.
Thanks, Will.
again.
Thank you.
All right.
All right. If you have a legal question for Will, you can email him at wworsham@color10.com. And of course, as you see, he'll answer your question on the show. Coming up, Kyle Wiley Pickett is here to talk about the Springfield Symphony Orchestra's next performance and his socks. Don't go away.
He's got some good ones today.
Does he?
Yeah.